Hi, everyone. Good evening if you're on the East Coast. Good afternoon if you're on the West Coast. If you're somewhere in between, good evening, I think. So I'm Molly. I'm the Executive Director here at the RAL National Association. I'm here with Michelle Pinkowski. And as I said in my invite, she's our favorite presenter ever. She always brings in people by the hundreds to watch these presentations and, of course, ask plenty of questions. So keep those questions handy. We're going to answer those at the end. Michelle today is going to be talking about, of course, pandemic COVID-19 related liability, risk management, and what you guys can do to avoid some of those risks that this pandemic has, of course, put us all in. So if you have questions throughout the presentation, there is a questions tab on your right-hand side in your control panel. You can type in throughout the presentation, and I will try and answer anything that I may be able to help with technicality-wise, like, hey, you can't get your sound to work, that kind of thing. Otherwise, if there's a question that is portraying something that Michelle could probably answer, we'll wait till the very end of the presentation, and then Michelle will go through and answer plenty of questions at the end. So, Michelle, thank you, as always, for being here and doing this with us. So I'm going to hand things over to you.
Thanks, Molly. Thanks for inviting me. It's always so great to be with our RALNA friends, and great to have everybody here. Sorry I can't see you, but I look forward to seeing everybody soon at the convention coming up. So as Molly said, I'm a lawyer. For those of you who don't know me, my name is Michelle Pinkowski, and my law firm is Pinkowski Law and Policy Group. And my husband Brian and I have been working with RALNA and people from RALNA, members of RALNA, for several years now. And we spend pretty much all of our time on legal issues related to assisted living and other group home and senior care. So this is a seminar that I've been wanting to do probably for the last year, COVID liability risk management for RALs and group homes. But I've been going back and forth on it because I thought, do we know yet what the risks are? And for a while we didn't. It takes a little while after something like this happens. I know it's still happening, but it takes a little while before the legal system starts to react. So I didn't really have enough certainty of what to tell you, and I still don't. You'll see as we go through. I'm going to give you what I know today, but things are continuing to change really, really quickly. So we'll just go with what it is today, and you will just have to be aware that you have to keep up on it. The other reason this has been kind of long in production is that it's not something that I do every day anymore, but I don't know if all of you know, I used to be a litigator. This is what I did all of the time until people who love me told me I wasn't very nice when I was fighting with people all the time, every day. But I still, it's kind of like a retired football player, still pay attention to the game. I still monitor that and still do some litigation for clients. And certainly this is something that we pay attention to when we advise our clients on risk management. So I'd really like to find ways to keep you out of court. That's really my main goal now, even though I loved being in court. But when you have been in litigation for as long as I was, you start getting a sense of when the risks are there. It's kind of like somebody with a water witch or something, those little forked things where you go and try to, it vibrates when there's water. I get that sense when there are risks in an environment. And sometimes I drive my son crazy with that, of course, because I'm always seeing risks that I'm trying to prevent for him. But in this case, I hope that it's useful for you, because I am starting to feel like we are at some crossroads on a few areas where the risk is, oddly enough, it's a little bit higher now than it was earlier in the pandemic. And I'll explain why that is as we go through. So let me just get through this here and make sure my slides are set up correctly. I don't see this switching on the view. Molly, can you pop in and tell me if you see the second slide that I just clicked on?
It doesn't look like it switched. Did it switch on your end, but it didn't switch over here?
It did, yeah, it did. So let me try something different here.
Maybe stop share for a moment of your screen and then reshare.
Okay. All right, here we go.
All right, you're back.
There, we're back on now, right?
Did you switch to the second?
Now I
There you go.
switch to the second. Okay, perfect. So what we're going to talk about today are 3 potential liability areas that you should be aware of. One is liability to residents. We are seeing more and more claims coming now to the court against mostly nursing homes, but assisted living as well, from residents who have experienced serious injuries or death in a long-term care. We know, of course, this is no surprise to anybody, it's not news, that people in long-term care have suffered from COVID, and it's not surprising that the plaintiff's bar is responding to that and bringing lawsuits. So I'm going to talk to you about what we're seeing, the kind of claims that we're seeing, and the fact that it's not over yet. So what do you need to do to protect yourself against claims in the future? We'll also talk about liability related to employees and to guests, people that come into your assisted living home or your group home. Do you have liability to them? Now, full disclaimer, you know I do this every time. This webinar is for educational purposes only. I'm not giving you legal advice. We're not forming an attorney-client relationship. You need to check. What I'm trying to do is provoke some awareness for you so that you can develop questions for your local counsel if you have them, or know whether you should be asking questions. So it's really educational for you. And also, as I said before, the state of the law on this is changing really rapidly. So it's just something that you have to keep up on. So let's talk first about liability to residents. The type of claims, the names of the claims that we're seeing range from negligence and wrongful death to elder abuse and neglect, or intentional infliction of emotional distress. And sometimes that's asserted by family members of people who have passed away in long-term care. But there's a number of different names to the types of claims, but those are some of them. Now, when we talk about liability for COVID-related claims, we have to divide states up into states without liability protection laws and states with liability protection laws. Some of you on this webinar might have heard me talk before. I think it was, earlier this year, about how at RALNA we've been monitoring legislation. And a lot of that legislation has had to do with liability protection for COVID-related claims. So on the RALNA legislation tracking website that you can go onto, you can see all of the pending or enacted legislation. And I'll do an updated blog within the next couple of weeks to just make sure that's fully up to date, because what's happened is some states did pass liability protection laws. And what that means is it protects businesses from claims related to COVID. So some states passed them. Some states had the bills introduced, but it never passed the legislature, and now we're out of the legislative session, so those bills are dead. And whether they'll be reenacted or reintroduced in the next session, we don't know. But right now we have 2 categories of states. We have states without liability protection laws, and we have states with liability protection laws. So let's start with the states that don't have any specific statute related to COVID liability. There's a number of states, mine, Colorado, it was introduced but never passed. So basically it's status quo when it comes to liability for personal injury claims in Colorado. So if your state is like that, basically we're going to be looking at the most common kind of claim is going to be a negligence claim. So when somebody says negligence, what does that really mean? I'll give you the legal definitions. There's not going to be any tests, don't worry, but just so that you can understand what does it mean when you're being held to a standard of negligence. Basically, it's the failure to exercise reasonable care. So reasonable care is that degree of care that a reasonably careful person would use under the same or similar circumstances. The other definition I have up here is basically failure to do an act that a reasonably careful person would do, or doing an act that a reasonably careful person would not do under the same or similar circumstances. And what that means is you're going to be judged in your group, right? So you're going to be judged in the group of people who have an assisted living home. You shouldn't be compared to somebody in a skilled nursing facility, or somebody in a restaurant, or somebody in a meat processing facility. It's the same or similar circumstances. So you're judged in your context, if that makes sense. And how is that, who determines what's reasonable? In the end, if there is a lawsuit, there's going to be expert testimony on both sides, and there'll be an expert that says this assisted living home acted reasonably, and an expert on the other side that says no, they didn't, and this is why. Ultimately, it's up to a jury. And a jury comes from people pulled from your local area. They might not all have the same perspective as you do, but it's going to be people pulled from your local area. So let me just stop for just 1 second too and say, when we talk about perspective, I know everybody on this call has their own perspective on COVID-related issues. Okay, it's whether it's political or not political, or our own personally held beliefs, whatever. I recognize and honor all of those beliefs that you have. For the purposes of talking about risk management in this webinar, I'm going to ask you just to put that aside, put your personal beliefs aside just for the course of this webinar, and only wear your business risk manager hat. Okay, because we really need to look at these business risks just with a steely-eyed stare and really confront them as they are, without the lens of our personal viewpoint on the issue, because it's been a hard road and all of us have that personal viewpoint. But just for this webinar, put it aside for just a little bit, just wear that hat of the business owner and try to be as objective as possible when you're evaluating your risks, because the whole purpose of this is not to get political or be an advocate one way or the other. The purpose of this webinar is to advise you so that you can protect your business, you can protect your residents and your employees and yourself, and manage your risk the best you can. And the only way we can do that is if it's not an emotional decision. So that having been said, back to the jury issue, whether something was reasonable is going to be ultimately up to a jury, but you kind of have to predict. So today, you have to be thinking, what would a jury think was reasonable under the circumstances? Keeping in mind that a jury won't see this issue. Like if something happened to you today and you get sued for it, it's not going to go in front of a jury for 18 months, 2 years, 3 years. And at that time, let's all hope the pandemic is over and people are now viewing things with 20/20 hindsight. Other people are going to be viewing what you're doing with 20/20 hindsight. So it can be a little bit different perspective. So the question will be, once it gets to a jury, were the actions taken today reasonable under the circumstances? So if you're in a state that doesn't have the COVID liability protection law, that's going to be the biggest risk of a claim is negligence. But there's another claim as well. Because our industry is regulated, there's lots of regulations that have come up, laws and regulations, but mostly regulations when it comes to operations, passed by the health department or whatever your regulator is. And those regulations can form the basis of a type of claim that is negligence as a matter of law. The legal term is negligence per se. It means just negligence as a matter of law. If there was a violation of a law or a regulation, then the court could find that that is negligence as a matter of law. So it takes out the consideration of was it reasonable or not. It's just, did you follow the regulation or not? And if you didn't, was that the result? Was that the cause of the injury that happened? So if there are regulations in your locality, and I'm sure that there are, that's the biggest risk management point. Number one, make sure you're following them to the best of your ability. Now, you'll notice here that you can have an excuse for not following the regulation. So if you're thinking that, for example, early in the pandemic, regulators said you have to have PPE, but we couldn't find PPE. You know, we didn't have enough. That's an excuse for not following that regulation. But the best risk management tip I can give you here is make sure you document. If you have any kind of excuse, if you're not following a regulation for some reason or another, document why you didn't. And, you know, we know the regulations have been changing too. So just if you make different decisions based on the changing regulations, just make sure to document it. And that will help a lot down the road. Let's talk about states with liability protection laws. I can't tell you exactly all of that there are, but there have been a lot. There have been a lot. And what those states generally say in their statute is, unless someone exercised more than mere negligence, it has to be gross negligence or willful or wanton conduct. Unless there was that kind of bad conduct, you're protected from any claim for COVID-related liability. So the question here then is, does your state have that kind of a law? Does the liability protection extend to assisted living? And that's the kicker. For example, New York had an immunity statute that covered healthcare. It would have covered nursing homes and assisted living, and then they repealed it. So now New York doesn't have the statute anymore. Some states still do have the statute, but have made it not apply to what they call healthcare settings. So the question is, are you considered healthcare? In assisted living, we have to really look at the definitions of healthcare because we know we're not a medical model. So do we fall within the definition of healthcare or not? So that's question number 2. Question number 1 is, does your state have a law like that? 2, does it apply to you? Does it provide you with protection? The third question is there any expiration date? Because I have seen these liability protection laws that expire after a certain date. You know, everybody thought the pandemic would be over by X date, and that's when the law expired. And so that's when the liability protection ends. Or the liability protection ends once it's not a declared emergency. And there have been some states to question whether it's still a declared emergency or not. So that's the question. And here is one of those areas where my antennae are going up about a level of risk that we really have to be aware of. Because if those laws are sunsetting, so that umbrella protection might not be there, but we know Delta cases are still rising. You know, COVID's not gone yet. Are you going to find yourself at a time when the risk is still there, but the protection is not? So that's why I put the top picture up here, that, you know, you can look all cute and sassy in the rain as long as you have the umbrella. But, you know, on that picture, if the umbrella blows away, it's going to be a mess, man. There's going to be mascara smeared everywhere. It's not, you know, there's no more protection, and she's not ready for it. And that's what it would be like if someone is relying solely on the liability protection law to provide the risk management for their business. Unlike the little girl in the rain on the bottom picture, you see she's got an umbrella, but it's really just for decoration because she's got that little raincoat. She's all covered up. An umbrella could blow away and she's going to be fine in the rain because she's got her own protection, and she's going to be just loving it and still having fun. So that's the third point that I would recommend. Even if you have that liability protection law in your state, I wouldn't see that as the floor for what you do. I would evaluate whether there's other actions you need to take to prevent against or protect against the risks that are still out there. Does that make sense? All right. Now, there is a potential liability protection under federal law. Some people have been trying to use this. I'm not going to go into this too much because it's really complex, but that's to say, you might remember early on in the pandemic with all the COVID relief legislation, there was a lot of talk in Congress about putting in liability protections, but that never got passed. That never got put in any of the COVID-related federal laws. But it turns out there's an earlier law that some people have been arguing. It's called the Public Readiness and Emergency Preparedness Act, or otherwise known as the PrEP Act. And as I mentioned, it's a little bit convoluted about how it applies, so I'm not going to really go into it, but suffice it to say that the basic premise that people are arguing is that if they were trying to provide means of countermeasures against COVID, then they are protected from liability. So specifically, there was a case called Gilbert Garcia against Welltower Group. This was an assisted living facility, and there was a gentleman there who had some comorbidities. You know, he had some health issues, but he was generally healthy, but he contracted COVID and died, and his family sued the facility in state court. And the facility bumped the case up to federal court, saying we should come under this federal statute. And not only does that preclude all the state claims, but it gives us complete and total immunity. And the court in the Garcia case said, yes, that's true. We agree with that, that under the PrEP Act, as long as, because the facility was taking measures, the allegation was that they didn't do enough. They had PPE, but they didn't do enough for infection control. They had policies in place, but they weren't sufficient. And the court said that is specifically gets them under the PrEP Act. And so they had complete and total immunity from the claim, and it dismissed the claim. Now, I say that with some hesitation because a lot of other federal courts have considered similar issues, and they've refused to find in the same way that the Garcia court did. So that's not to say that the PrEP Act doesn't provide immunity. It just doesn't provide immunity in federal court. So that's kind of a big issue that's up in the air right now. State courts might be ruling on it soon, but in my research for this webinar, I didn't find any yet. So we're going to have to just watch that and see. But even under Garcia, and even if the PrEP Act were to apply, there is no protection whatsoever if no countermeasures were taken. So if there was an assisted living facility that didn't do anything to protect against COVID, like nothing at all, there would be no benefit of the liability protection from this act. You just don't get any liability protection. All right, so hold your questions on that. We'll come back. I'll answer whatever questions you have in that area at the end. But now I want to go on quickly to liability to visitors. So people are coming into your home, probably family members, maybe it's service providers. Do you have any liability to them if they contract COVID? Now, the answer to that question will be similar to liability to residents. Maybe there's a liability protection law in your state, in which case it probably covers visitors, clergy, everybody. You're going to be immune from suit there. But if there's no liability protection law, then it's the same as under regular law. Like if somebody came to your apartment building and slipped and fell, what standard would be applied to that? You know, similar negligence standard, a premises liability analysis. So same thing with COVID. I don't see that there's anything different, except the big difference is even if there might be a claim that they conceptually could bring, I think it's going to be really, really difficult for them to prove that they got COVID from your facility. If somebody's going in and out and they're interacting in the community, given the current state of community spread, I think it's going to be really, really difficult to be able to prove a case. So I don't really think we're going to be seeing many, if any, claims from visitors. Now, here's a different question, though. Can visitors create liability for you vis-a-vis your residents? So if you're allowing visitors to come in and somebody brings in COVID and then your residents get sick, can one of your residents or their family sue you? That's just a risk that you're going to have to evaluate. Like, what measures are you putting into place? So it's the same kind of question. Did you do something that was reasonable under the circumstances? Or conversely, did you fail to do something that would have been reasonable under the circumstances, in which case you could have liability? So that's something that you have to evaluate when you are looking at what are your policies regarding visitors. And, you know, are you checking temperatures? Are you making them wear masks? Are you requiring proof of vaccination? Are you requiring social distancing? Whatever measures you're taking, are they reasonable under the circumstances? So you just have to review those policies and make that determination. All right, let's talk about liability to workers. Now, we know that on-the-job injuries are generally covered by workers' compensation, and you probably have workers' comp insurance, right? But what if a worker gets COVID? Is that considered an on-the-job injury? Is COVID an occupational disease that arises out of and in the course of employment? So some states have a presumption that certain workers working in certain industries, if they get COVID, they're presumed to have gotten it on the job. First responders and healthcare workers are generally in that category. But then the question is, if your state has that kind of presumption, again, are you under healthcare workers? Do your assisted living caregivers fall under the definition of healthcare workers, so that there's a presumption that if they get COVID, they got it in your home? That's the question. If they got COVID and they bring a workers' compensation case, they're going to have to prove that, you know, they got the disease on the job, unless there's this presumption given to them by statute. So I know that there are, at least in last year, a number of states that enacted these presumption statutes. Those were Alaska, California, Illinois, Minnesota, New Jersey, Utah, Vermont, Wisconsin, and Wyoming. But a number of those statutes, again, like the liability protection statutes, were time limited. So they might have expired. Now, our initial research at least shows us that so far this year, Alaska, Illinois, Minnesota, Vermont, and Wyoming have renewed their statutes. So in those states, there's going to be a presumption of on-the-job occupational injury if somebody comes down with COVID, assuming that their, you know, assisted living is a covered industry in those statutes. Normally, diseases like colds and flu are not covered by workers' compensation, but we know, you know, COVID is different. And especially if there's been an outbreak in a home or a facility, it's going to be easier to prove that nexus, that causal nexus, or the connection between the infection and the occupation, the job, so that they can claim workers' compensation. Let's see if there's anything else I wanted to tell you on this. No, I think that is it. So here's some kind of best practices or risk management things you might want to consider, because obviously we want to keep our workers safe because it's the right thing to do, and to protect against claims, of course. So put some steps in place to do that. Something might be like daily wellness checks, taking temperature, asking them if they've been in contact with anybody that's been exposed, if they've been feeling poorly, you know, et cetera, all of those things that you know how to do. But here's one that perhaps you didn't think about. Have a standardized procedure to find out if an employee may have contracted the virus at work or elsewhere. Basically have a standardized procedure for contact tracing. So if one of your employees comes down with COVID, have a procedure in place that you can just immediately go in and start doing that investigation to try to track down where they came down with it. Because that investigation might show that nobody else in the home has it. None of your other workers have it, none of the residents have it. And it's important that you document that, and that will help you if, you know, they ultimately bring a work comp claim. Okay, now how's everybody feeling with that business risk management hat on and emotions aside, right? Everybody good there? Are we we're okay there because I'm going to move on to a topic, and I don't want anybody figuratively to throw anything at me, okay? But people have been asking this, and it's been a subject of a lot of conversation and discussion in the legal community and elsewhere. So, you know, we talk about things that are even hard, so we're going to talk about this. So hang on, here we go. Vaccine mandates. Okay, what is required of you to keep your workers safe? And what personal choices should be afforded to caregivers? And if you decide to give them personal choice, does that create liability for you with respect to your residents or other caregivers? And is this something that you should do to have a vaccine mandate? One of the first things you have to look at if you're considering a vaccine mandate is to determine whether you want an actual mandate or not. So you've probably heard of some employers, they'll say, get a vaccine, or if you don't want to be vaccinated, you just have to wear a mask when you're at work and get tested once a week or twice a week or whatever it is. If you have those alternatives, you can be vaccinated or not. But if you're not, you have to wear a mask. Then it's not an actual mandate because there are options that employees can choose from. If it is a mandate, like everybody has to get it, regardless, there's not going to be any choice between a vaccine and a mask, everybody has to get it, then that would be a mandate. And you should know that the case law is on your side, at least for now. So I'm going to tell you, just so you're fully informed on it, what are the courts saying about vaccine mandates? And you've probably heard a little bit about this in the news, but I want you to hear it from me from the actual legal perspective, because news media may or may not give you the legal facts that you need for your risk management decisions. So I am going to try to do that right now. There are already some states that require vaccinations for long-term care workers. I put a little asterisk here because you have to check your state. Again, do we fall under the long-term care worker definition or healthcare worker definition or not? You have to look and see what your state says. And a lot of this, it's a little bit hard for us to track on the RALNA legislative tracker because a lot of these orders are executive orders. They're not laws that are passed the legislature, they're executive orders. But these are the states that have some form of vaccine requirement for people in long-term care, which may or may not apply to you, depending on whether the definition of long-term care applies to assisted living. But they are California, Connecticut, Delaware, District of Columbia, Maine, Maryland, Massachusetts, New Jersey, New Mexico, New York, Oregon, Puerto Rico, Rhode Island, and Washington. And for my friends in Colorado, the governor has just asked recently in the last few days, the Department of Health to come up with a policy about whether healthcare workers should be vaccinated or not. Now, these are different requirements. What we hear about a lot on the news are requirements for public service workers. You know, if you're employed by the government, some governments are saying you have to be vaccinated. These are different because we're private. You know, these are private employers and employees, so they wouldn't be covered by that broad public mandate. Now, if you're working in a state-funded hospital, then you're a state employee and you're covered by that requirement. But the states that I have listed here are the ones that have some form of vaccine requirement for healthcare workers in private facilities. And probably this list is going to change even maybe by the time, you know, we're saying it now. Also, some of these have some caveats in them that people either have to be vaccinated or wear a mask. So some of these are not complete mandates, as I mentioned before. They're partial, vaccinated or wear a mask and be tested. But there's some kind of requirement that you should know about. So if you're in one of these states, make sure you know what the rules are. Conversely, because of course we have to have two sides of this issue in this country right now. Conversely, there are some states that say you cannot mandate vaccines for your employees. Montana and North Dakota have said this. However, those laws, and to the best of my knowledge right now, those laws in Montana and North Dakota just say you can't mandate vaccines that are only approved through emergency authorization. And we know, of course, that Pfizer has now been fully approved by the FDA. So these laws may no longer really be applicable if you are going to mandate that your employees get an approved vaccine. Wisconsin is different though. Wisconsin has a total ban on requiring a COVID vaccine. It doesn't matter if it's emergency authorization or full authorization, complete ban. Some bills have been proposed. North Carolina proposed a bill to make it so employers could not mandate the vaccine, but that didn't pass and it's lapsed now, so it kind of expired. But in Ohio, there is still a bill pending. So we'll just have to watch that. And I am going to set this up as a special sheet for the RALNA legislative tracking too, because I think this is really something we need to know about, even though it's a little bit difficult to track because it's not always legislative. So that's what the legislatures are saying. Let me tell you what the courts are saying. Excuse me. The first real case, perhaps you've heard about this case. This is the most notorious case that we have right now, or the most highly publicized, and this is Bridges versus the Houston Methodist Hospital. This was a group of healthcare workers that sued the hospital because the hospital said that all staff had to be vaccinated, and they gave a certain date. And if staff weren't vaccinated by a certain date, then they would start termination proceedings. So 100-some employees sued in federal court. It went to a federal judge that has been on the bench a very long time. He was appointed by Ronald Reagan, and he sits in Texas, so we're assuming this is a fairly conservative judge. And that judge dismissed the case. And he did it because he relied on an age-old principle of employment law that we have. It's pretty ingrained in our legal system in this country, and that is called employment at will. And that says the employer can set conditions of employment, and if employees don't want to comply with the conditions, they are free to work elsewhere. And that's what this judge said. The trial court said employment is at will in Texas. Texas has only one exception to that rule or that principle, and that is if the employer is asking you to do something illegal. He says this isn't asking people to do something illegal, so we default back to our standard principle of employment at will. Employers can impose conditions of employment, and if that's unacceptable, then the plaintiffs can choose to work someplace else. That case now is on appeal to the Fifth Circuit, so that's going to be very interesting to watch this case, the Bridges case, as it goes through the system. There was another highly publicized case. You've probably heard about this one too. This is the case against Indiana University. This is a little bit of it's harder to make the analogy here because Indiana University is a state university, and you know, there are some different issues here, but there are some points that we can use as an analogy and as instructive if you're looking at a vaccine mandate. In this case, Indiana University told students if they want to come back to school, they need to be vaccinated or they have to wear a mask and get tested twice a week. And they also provided exemptions for religious or medical purposes. That was their policy. A group of students sued. They lost at the trial court. That was appealed to the Seventh Circuit. Seventh Circuit is in Indiana, and that area, a very, very conservative circuit, and they lost there as well. The Seventh Circuit said that, well, the plaintiffs argued that the requirement violated the Constitution. It's against due process, it's unconstitutional. The Seventh Circuit said, no, we don't buy that argument. They relied on a very old case, which was something that I learned. It was very interesting, from 1905, that says a state may require members of the public to be vaccinated. In this case, it was against smallpox. But that's still the law in this country, that a state can require vaccination against a communicable disease. So the Seventh Circuit relied on this old case from 1905. It said the school gave students a choice. It wasn't a full mandate. They gave the students a choice, and the students can choose either of those things, the vaccine, the mask, or to go to other schools, because there are other schools that don't have that requirement. So personal choice in that instance came down to being able to go to a school that doesn't have that requirement. The plaintiffs appealed that in what's called an emergency application for writ of injunction. Basically, they appealed it on an emergency basis to the Supreme Court, and Justice Barrett denied it and sent it back. So this case, I don't think this is going anyplace else. So this is instructive law at the moment. That is not all of the case law, full disclosure. There is another case out of Louisiana that ruled the opposite way. The school kind of really did a bad job with imposing vaccines and went back and forth a lot. But Louisiana, in that case, Louisiana is on a different legal system than the rest of the country. I won't get into that, but just to say the other case was solely based on Louisiana law. So it's not really going to be instructive for other places in the country. But if you're in Louisiana, you probably want to look it up. I will also tell you, however, that despite these two cases, the Bridges case and the Indiana University case, despite that, there is still talk amongst the plaintiffs' bar. I saw it in the Colorado lawyer chit-chat room just this last week, where people are considering bringing suits against employers for vaccine mandates. So the issue is not dead. And I put that out there just to say, if you're going to have a vaccine mandate, you probably want to take some of the pieces that were instructive from these cases, in that there were potentially choices, but if not choices, heavily relied on the employment at will doctrine. Also, there is an EEOC guidance. This is not law, this is just guidance. But remember, if somebody wants to bring a suit against you, generally they have to go to the Equal Employment Opportunity Commission and pursue a remedy there first before they sue you. And the EEOC has said that employers can require vaccinations, subject to reasonable accommodation for disabilities or a medical exception, or sincerely held religious beliefs that preclude vaccination. So this is the position of the EEOC. It's not law, though. It's just guidance on how the EEOC might react if a claim got there. All right. And so now, since we've gone through that divisive topic, I thought everybody would need to see a little picture of kittens just to settle down and take a breath. And I'll open it up to questions. And I hope that was helpful. Molly, do we have any questions?
We sure do. So I'm sure there's probably more questions that are going to come in. So don't worry. We'll save time for more questions, guys. The first question that came in says, why didn't Colorado pass the liability protection law, and what can I do to help get this law passed?
Oh, well, because the straight answer is Colorado is completely blue right now, and the liability protection law is not going to get through our legislature anytime in the near future. It was pending, and now our session has lapsed also. So to have that law be live again, if you will, it has to be reintroduced. So right now the law is dead. It would have to be reintroduced. And you know, okay, I'm not going to just go the red and blue answer. That's not the final word on it. If there were some showing from the industry that, look, we just cannot handle the volume of COVID-related claims, and you really need to think about this, then the legislators need to think about that. So it can be reintroduced. If you have a legislator, I would be in touch with them and say, look, we really need this, and this is why. That's my best guess.
Go. That was a terrific answer. Straight to the point. Becky says, thanks for the kittens and all the valuable. She said, I've heard rumor adult care home caregivers must now be vaccinated in Kansas City, looking for confirmation on the state website. It seems like that's similar. I talked to somebody in Oregon today that said that that was similar to the mandates that they were seeing there. So it's going to be something that you guys see, obviously. And we've been hearing from members about it a lot too.
Definitely. Yeah.
Okay, the next one says, can you create a waiver for resident and or power of attorney to sign upon admission to the RAL in order to protect themselves? Yeah.
A liability waiver? That's a really good question. That is a very state-specific question. Potentially you can, though. It would behoove you to put something in your resident agreement, because if it's not COVID, there's other things that go around. You know, there's the flu, there's other things that can affect people. And so if you just have something up front that says, this acknowledges that we understand living in congregate care settings, there is some risk that there could be infectious diseases, that might provide some protection. I would definitely work with your local attorney to draft the specific language of that, because it is very state specific.
Perfect. The next one says, I have an assisted living facility and I heard you mention a few times that assisted living workers may not be considered healthcare workers. How do we argue that they aren't? So are not healthcare workers.
Really, the first thing you have to do is look at the relevant statute in your state to see how it's defined. And that definition is going to be controlling. I think if there's new legislation being proposed, it's a little bit hard to argue. The main thing, even though assisted living caregivers are not providing medical care, the main issue is the congregate living situation. And the risk of transmissibility in that environment is high. So I think legislators are going to be a little bit hesitant to exempt assisted living from that definition. But that's, again, something, first find out what the statute says, or if there's a statute pending, you can work with your elected representative to get the wording to be appropriate.
All right. The next question says, can we insist visitors are vaccinated to see their seniors in person? Have you heard of any facilities trying to do this?
I have not heard of any facilities trying to do this. And this is really an interesting question, because we have a resident rights. Usually, under Colorado regulations, for example, residents have a right to have visitors, but facilities also have a right to make sure that that visitation is safe. I have not seen any cases or anybody writing on that particular topic. I would think, though, given that there are some states, actually, this is something we've been tracking from RALNA, that mandate that residents be allowed to have visitors. So if there is such a state statute, I mean, there might be by statute, but then other states have these resident Bill of Rights that say that residents have to be able to have visitors, or at least, one designated, what do they call them? Not caregiver, but important person that can come visit them. So I think requiring vaccines for them might be difficult. I'm not saying you can't, but it might be difficult. What you might want to do is say that they have to show proof of vaccination or take the other safety precautions, the wellness, the temperature check, the mask, the social distancing, etc.
Yeah, and just a side note there, I've seen a lot of people using those little, it's almost like a little stand that has a temperature scanner. When they walk in the front door, it just scans their temperature so that you don't have to have a staff member that's doing it. So it logs everything for you. That's really cool.
Yeah, that's really cool. My massage place has that, actually.
Yeah,
it's very handy.
Exactly. So going back to mandating vaccines, obviously it's going to be a big topic here. So they are talking about, this next question is talking about hearing or thinking that mandated vaccines for facilities receiving Medicaid funds has been put in place already. Do you know anything about that?
You know, maybe it has. I'm not sure, to be very honest with you. Yeah, I did not, in preparation for this webinar today, I didn't have a chance to look at that, but that may well be the case. And if so, if you find that, could you share it with us? Put it on the Facebook page or something? That'd be really good to know.
Yeah, Dora, please, wherever you got that information from, definitely share, for sure.
Yeah.
The next thing says, since we own private homes, can we mandate that any new worker need to get vaccinated?
Yes, you can. Well, unless you're in one of those states that says that you can't, you can mandate new workers and existing workers, because it's always employment at will, just like the Houston Methodist case. That's what they did. That the mandate from that hospital system, and it was a big hospital with a lot of workers. It mandated that all workers, existing, new, whatever, that they be vaccinated by a certain date. You have to give people time to get vaccinated. So you set a date in the future that says, you know, you have to be fully vaccinated by X date. And then also put in your policy what happens if they're not. You know, what are the ramifications?
This resident says this owner says that they only allow visiting nurses who've been vaccinated. Is that legal? So do you see them running into any issues by only saying they allow nurses that have been vaccinated in their care home?
I would say, without giving legal advice, of course, I would say that, I mean, if it's a service provider, not a family member, to see the resident, I would think that you would be on pretty solid legal ground right now. Again, it depends on your state, and things are changing, but that could be a solid requirement.
And a lot of these questions, you guys, this is going to depend on your state, right? It's going to depend on what your state mandates and what your state health department requires, those kinds of things. I mean, obviously, I'm in here in Arizona, and Arizona is, you know, almost like a free for all. I feel like there's no real regulations in place, whereas there are other states that are very, very strict. So, Deanna, this question may or may not be able to be answered by Michelle, but she's saying, if a vaccine card is shown as proof that they were vaccinated, is that sufficient? Or do you see that needing further verification, as in like with a verification database kind of thing?
Gosh, I think you'd have to make that call, you know, yourself as a business owner. It's funny because, you know, I do work internationally. I have a lot of international friends, and I've been hearing people that travel from the US, and we have our little vaccination cards, and people in other countries, because they look so informal, these other officials laugh at them, and they don't believe that that's actually our proof of vaccination. So, you know, there have been some reports about false, you know, counterfeit vaccination cards. So I guess you could reserve the right, if you see something that doesn't look quite right to you, reserve the right to have some kind of verification. You know, I don't know what all states are doing with respect to their verification and how easy it is. I'll just give you another example. All of my examples are from Colorado because this is where I'm at, but we have a state database, and I should be able to download an application on my phone and then pull it up and show people, you know, from the state database that I'm fully vaccinated. But of course, the app doesn't really work for me. So all I have is my vaccination card. So I think because we don't really have a standardized procedure, it's going to be hard to request something other than just the vaccination card. But if you are requesting to see the vaccination card, you know, that is proof that you are trying to take steps to act reasonably to prevent risk and prevent the risk of harm. That's the best answer I can do on that one, sorry.
Well, and documentation, I think, is everything. If anything, you guys know about this firsthand. Documenting everything, documenting your processes for everything, just having that documentation in place is going to be protection for you in one step of it, right? So totally. I also wanted to say to you guys, because I'm sure Michelle can relate to this, every state holds data differently. Every state organizes things differently. For some reason, there's no cohesive standard of portraying data, or like you said with Michelle, holding it so that you can reference it later in the database. So from my research that I've done in state health departments and how they just track care homes in general, it's not easy to say that they're going to be the same in each state. So if you have a database to reference, then yeah, of course you have that double check, but it sounds like Michelle doesn't have a reliable database yet, at least. Yeah. And so you may not have one just yet.
That's right. And you know, while we're talking about different things in different states, I do want to emphasize something else. And this is why we have to just wear our, you know, more impartial business owner hat when we look at these risks. It's because even if you're in a state like Texas or Florida, you know, I know that views on COVID and vaccinations sometimes in places like that, at least if we, you know, from what we hear on the news, are different than in other places, in Colorado or Washington or whatever. But I will tell you that some of the most prolific and, may I say, vicious or really, really accomplished trial lawyers, like people who have done so well as trial lawyers, they own their own islands and stuff, are from Texas and Florida. So because the trial bar, the plaintiff's trial bar is really strong in those states, you have to view this very dispassionately, because the plaintiff's lawyers aren't going to care what our personal views are on something when they're looking at a lawsuit.
Yeah, and Maggie thinks she's in Colorado and the app doesn't work for her either. So
yeah,
you're not alone.
Right. Best intentions.
All right. Well, guys, it looks like that's the last question. These were such great questions. And Michelle, this was such a controversial topic. I was like nervous a little bit for you to present on this, but you're an attorney, so you're used to this, right? You're presenting on controversial topics.
Absolutely, so and we know this is a safe space. We know at RALNA we have to talk about the things that we want to talk about in this safe environment.
Yeah, and there's lots of risks associated with every business, not just assisted living. So there's plenty of businesses other than assisted living that are talking about these same exact things and trying to decide what's the best route to go. So document, document, document. It sounds like what Michelle just said. Just document your process. Make sure you're showing that you're trying to keep people safe, and you should be good.
Absolutely. That's right.
All right, everyone. Have a wonderful evening. Michelle, I really appreciate you. Thank you for doing this tonight. And everyone is just saying thank you so much. And it's been super informative.
I'm glad. Thanks, everybody. Thank you, Molly. Take care. Bye.